This is the second AI panel of 3. I am not Luigi Zingales. So Luigi, I gather, is at home not feeling well. That is a loss for all of us. There is no good substitute for Luigi. More Luigi is always better than less Luigi. But I'm happy to have a chance to interact with people on this panel. I'm supposed to remind you, I'm told, about the QR codes and the polls. So please do those so we can suck up as much data from you as possible. So make sure you participate in that. All right. So the first AI panel sort of nudged into a little bit what we want to talk about. So that turns out to be great. So questions of privacy and copyright and control over the underlying data, and then how that might feed into AI. That's what we're going to talk about here. We've got 3 people to do that. Stefan Bechtold from ETH Zurich works in these areas, does experimental work, works outside of these areas. I will say, I heard Filippo mention mountains and cows. If you get a chance to go visit ETH Zurich, say yes to that invitation. I did that. You should absolutely do that. Then we have Julie, and Julie is, I don't know, we've known each other for years, right? Yeah, for years, exactly. Georgetown, decade, ooh, don't say that. Georgetown Law School, privacy, copyright. I teach a tech policy seminar at the law school. I've done Julie's books in that. We had a lively discussion. So that's our second person. And then Laura, who I didn't know until yesterday. My God. If you ask me, what I mean by that is, if you ask me what single antitrust case do I most want to settle, it's the Google ad tech case, so that I never have to understand it and teach it, right? And so to jump in and do that yesterday, I know you've got a deep background in it, but that was great and impressive, so I really appreciate that. We're going to do the same drill we've been doing all conference. We're going to do 7 minutes, and we're going to start right here. You're up.
Thanks. I didn't know yesterday we were doing disclosures, but for disclosures, I worked for the Department of Justice. I share technical expertise with the Australian Competition and Consumer Commission and with the consortium of Meta shareholders. Thank you so much to Filippo and Luigi, who's not here, and all the organizers, because this is such a fascinating place to come and have deep discussions about both innovation and competition, and that's very rare. So thank you. Okay, on to what I'm actually here to talk about, which is, so we are here to talk about large language models and some of the risks they pose to privacy and copyright. And the thing that occurred to me when I got this brief is, well, the actual technical origin of these 2 problems is exactly the same thing. It's the same technical problem. And so, yeah, I'm not a lawyer. These 2 will tell you about the law and the economics, but I really want you to understand why this problem happens and how, on a technical level, we can mitigate it, because actually that really matters for understanding what we should do about these problems. So I'm assuming that probably more people in this room than in a normal room have run just a simple regression analysis. And if you've ever done that, you're actually pretty far down the way to understanding what a large language model is doing and how it works. The big difference when we talk about the large transformer-based models is, instead of doing it over 2 dimensions with 2 features, they're doing it over hundreds of thousands or millions of parameters. That's really the primary difference, that and a little bit of randomness. And so the thing that you have to know is, when we're talking about large language models, what we're really talking about is, we take a big data corpus, we train a model that is just this complex multidimensional space. And in some spots in that big complex multidimensional space, the data are really thin. Maybe there's only one example of a thing that's like that, or maybe there are 5, but they're all functionally the same. They're all basically identical. When you get that, you get a technical problem called memorization. And what memorization is just the model spits out the exact same thing that's in the training data. So just to demonstrate what this is like, because this is something, hey, can you be my chat, Stigler? So what I'm gonna do is I'm gonna give you a sequence of tokens. This is the same exact thing that ChatGPT does. I'm gonna give you a prompt and you're gonna give me a one-word response. So here's your prompt. Dr. Laura Edelson, assistant professor of computer science at Northeastern University, has hair that is red. Great, one token, single example. Personally identifiable information, my hair color is red. There's a delta of information that was gained from that token, single example. But this problem doesn't just happen when we have a single example. This can also happen when you have really repetitive data. So let me give you a second prompt. Harry Potter boy wizard went to, great. Those prompts, that's really not that different than those kinds of model parameters that I mentioned. Just a window of text, just what we call a shingle. And we're just getting one more prompt in the end. Now, you can answer those questions because you understand things about the world. Large language models can answer those questions because they've seen those text strings. But really, fundamentally, that's all that's going on. It's not very complicated. And the reason that I want you to know this is that memorization is inevitable. We cannot build large language models. We cannot build transformer-based models that do not do this. What we can do, we can build applications that use large language models that do not violate people's privacy and don't output copyright violating material. But the only way to do that, all of the technical methods that are being developed to do this, they all operate on the application layer. So we are developing prompt tuning techniques that make prompts less likely to generate privacy revealing material. We are generating something called canaries, where we can build something into our training sets so that when a model outputs something that is just like one very narrow area of data, we actually know that that's happening. But we will always have to listen for that canary on the output layer. So the thing is, I think this is going to be really important for coming up with mitigations. The other thing that it really matters for is, again, I know I said this early in the day, so much of the conversation, the public conversation we're having is about these like big, enormous foundational models. And they're important. And there's more of them every month. But the vast majority of models that are being used are they're other fine-tuned models that maybe were started with a GPT model, or they started with Claude, or they started with Mixtral, and then they took that and then they were fine-tuned to do something business specific. These fine-tuned models are much more prone to memorization. And so if you want to think about where the harms are, you should be thinking much more about those purpose-specific fine-tuned models than you are thinking about foundational models, both because evaluations of harm are really going to be dependent on the application, and also because even if let's say we could wave a magic wand and I could take memorization out of GPT-4, which I can't and which no one can, but even if I could do that, it would not fix the problem with fine-tuned models that are based on GPT-4. Okay, I think that's...
So you're right near the time. Yes. That's perfect. Fantastic. Very much appreciate that. Julie, you're up.
Okay, so I want to talk about something completely different, thank God, because I'm not a computer scientist. I have done a bunch of copyright law in my life and a bunch of privacy law and a bunch of platform governance stuff. And what I want to talk about is actually not the output layer at all. What I want to talk about is what happens at the input, right? The training and then the retraining and the refining. So in order to learn anything, right, about properties of the world, right, about whether it's people and their behavior or whether it's the corpus of published knowledge, right, there needs to be training data. The training data may implicate, probably will implicate, people's intellectual property rights, may implicate, probably will implicate people's privacy. And it is very, very tempting to make one or both of two mistakes. Okay, so the first mistake is thinking, oh my God, it's an incentive problem, right? If people's copyrights or people's property rights are posing obstacles to ingesting this stuff as training data, then we need to worry about that, because what the world really needs is more incentives to develop, especially large foundational models. And probably you can imagine that my answer to that is that's nonsense, right? We do not see currently that under incentivization at all. What we see instead is the opposite, right? A race to ingest more and more and more and more and more, and claims made about the importance of more, to the point of needing to create synthetic content and synthetic data so that each model will have a more powerful frontier than the next one. So that frame doesn't work, right? The other frame that doesn't work so well either is the frame that says copyright is about, or privacy is about, giving an individual right holder individual control. And they're not, and the frame is wrong for different ways in those two contexts, right? So in the context of copyright, although there is a lovely myth, right, that each person's copyright is their individual thing that they get to control, the long arc of copyright over the 20th century and into the 21st is the kind of clearing away those obstacles to create institutional mechanisms for exploiting creative works at scale. Think about ASCAP, which goes back to the early 20th century, all the way up to the music licensing and performance rights royalties that are created more recently. All of which is to say, there's a lot of noise, there's a lot of Sturm und Drang about compensating right holders right now. This is a problem that we have seen before. There are solutions that we have seen before. I'm not terribly fussed about them. On the privacy side, there is, to my mind, a much more serious problem, right? That, and I think Stefan will talk about this too, in terms of purpose limitation and data minimization and other concepts that we have coming, especially from the GDPR and from data protection law. But any of those discussions takes the existing corpus of data as given. And what I want to encourage you to do is think about where that data is coming from now and how it came into being, right? So if you are, say, for example, training on all of YouTube, that's not unproblematic, right? The universe of user-generated content as it exists now has been called into being and optimized and structured and refined over time in the context of practices of kind of data creation and data curation focused around attention and engagement, right? In other words, particular items of data have been selected, right, as worthy of being collected. Software developer kits have been embedded. They're the forever chemicals of the internet, right? They've been stuck all over mobile operating systems, mobile apps, web pages, to pull particular kinds of data and not others. And so what is being trained on is a corpus of knowledge, right, or information that wants to measure and know and pattern particular kinds of information about people rather than other kinds that one might imagine creating instead. Same thing if you scrape, from everything else on the open internet. Same thing, which I gather is the OpenAI approach. Definitely the same thing if it's Amazon's platform and they're taking from their e-commerce and Alexa and Ring, right? And so and that's a different kind of a privacy problem with a nexus to the democratic harms comments that were being made yesterday and earlier today. There are various ways one could know things about people and populations of people, and it matters a very great deal what those things are and what information one decides is worthy of being harvested, collected, and curated. And if it is important not to get to get into a state of mind where we forget to question the provenance, as Ellen said earlier, of that data. There are questions about whether and how to incentivize development of AI that serves what we might decide are human interests, right, and human well-being are sort of inextricably entwined with the particular kinds of things that we choose to measure and know. So I've sort of ended up in kind of a meta place, but I think I've ended up also at 7 minutes.
You got 30 seconds to go if you want.
I'll just
You'll
hand
cede
off
them to the floor.
yes.
They're all yours.
Great. First, thanks a lot to Luigi and Filippo for inviting me. It's a great conference. It's a pleasure to be here. What I want to do is to talk a bit about, limitations to regulating this technology, in particular in a global, on a global scale. And this is based on a project that Filippo and Laura and I am actually working on. And so we're interested in, if you want to regulate AI, such as the European Union is trying to do, what are the limitations if you take into account that there are different, regulators, different countries on the globe that, try to do this, and also, companies can react differently to these regulations. And so the way we think about this is that, governments can basically either regulate conduct or effects, as they can do in other areas of the law, and they can regulate behavior on a domestic or on a global level. And in the few minutes that I have, I'll walk us through a bit what this means in the case of AI. So let's say, government has a regulatory problem. It, sees that there are copyright problems of authors or privacy problems, or there's market concentration. The first thing which it can do when it comes to AI, it can regulate conduct. So it can say, each time there's a company which develops this system and offers it to customers in our country, then we're going to intervene and impose certain rules on it. The company then can basically do two things. It can either comply or it can try to evade. Often, the companies will comply. California creates the CCPA, requires, companies to provide an opt-out of behavioral advertising. Google complies if you're a California resident, and you can opt out of behavioral advertising now. Sometimes companies find loopholes. So think about Google Books. So Google starts scanning books as part of the then called Google Print project in 2003. Under US copyright law, it was unclear whether this was covered by fair use. The Authors Guild files a lawsuit in 2005. It takes the court system about 10 years to figure this out. Second Circuit at some point held that fair use applies. From a European perspective, from a European copyright perspective, these things were not that clear because European copyright law doesn't have a broad fair use defense. And so there was a risk that, Google would basically violate European copyright laws on a massive scale. However, the actual scanning of the books took place in the States. And so the potential infringement was, according to territoriality principles under IP laws, was basically only happening in the States. And so by basically engineering, the entire scanning process and, locating it in the States, Google evaded kind of potential liability in Europe. And so for some technologies, this, arbitrage possibilities are easier and are harder. I've heard stories of European companies basically also doing their training for AI models in the States because they want to at least minimize their exposure to European legislation. Whether this is going to be successful basically depends then on what the government does. In this case, the European governments or the European Union. So if it's really important to the government, it can basically engage in effects-based regulation. It can say, irrespective of where you company, perform your action, we are going to apply our rules anyhow. And that's basically what the GDPR did. It says, data processing irrespective of where the data processing takes place, this data processing is subject to the GDPR as long as data subjects in the European Union are affected. And that was actually an innovation of the GDPR compared to earlier privacy regimes in Europe. The states United States has also done this. Some of you may remember the Cloud Act. FBI 10 years ago wants to access an email of a US citizen that's stored by Microsoft on a Hotmail server in Ireland. Microsoft declines to deliver that email. This leads to a lawsuit, and ultimately Congress passes the Cloud Act in 2018, basically compelling Microsoft to provide the data. And so basically governments can reply to these arbitrage possibilities by engaging in effects-based regulation. And whether this is going to be successful then really depends on how important this issue is both for governments and for companies. So sometimes governments do not play this game to the latest stage. So Google Book, for example, the European Union could have changed its IP laws and basically could have adopted an effects-based regime in other areas of IP law, satellite transmission. There are these cases, but it hasn't done it, and so Google Books could thrive. But in other areas, such as privacy and AI law, apparently the European Union thought it was so important that they switched to an effects-based regimes. So, whether governments, how far they go on this game really depends on how important the issue is for them. And the same is true for companies. Whether they will comply or try to exit depends on, relative costs and benefits, mobility of assets, and what the risk of non-compliance are. And so ultimately, that's what we're wondering is, what's the outcome of this game? And there are multiple possible outcomes. One outcome is international harmonization, where there is an international treaty where everyone gets together, harmonizes rules, not very likely in the case of AI. The other extreme, multiple local conduct-based regimes where just each country, creates its own regimes. Third option, unilateral imposition, basically kind of a Brussels effect, what you've arguably seen in privacy law. Perhaps that's going to be replicated in AI. Or in the extreme, just mere fragmentation, where each country does things differently. My current intuition on this is I'm not totally sure whether the European Union will be successful with the AI Act in terms of replicating the Brussels effect, what it did with the GDPR. And the reason being that this is an area where there may be just simply too much at stake for other countries. So whether they're just going to adapt or be willing to adhere to Brussels is not entirely clear. So I think it's more likely that we're going to end up in a regulatory regime for AI that lacks harmonization, but has some coordination among some countries, but that some conflict between these rules is unavoidable. That's all I want to say.
Great, thank you so much. That was super interesting. So I've been creating questions since I learned I was going to do this. Rachel, can we change this over? So I want to show something. So if we could do that. That's what I want to see. We're going to see if we can see it.
What did you do yesterday?
All right, they're going to come up. So here's what I'm going to set up while Rachel's dealing with that. So the memorization issue that Laura talks about, I think a particularly prominent example of it is in the New York Times OpenAI Microsoft case. So this is a copyright case. What's nice about cases like this is you have well-resourced parties with super sophisticated lawyers on both sides. And so this is the kind of case that you want to see what happens. And so that's what I'm excited about. And there's this exhibit, it's Exhibit J. There we go, yes? Thank you so much.
Can you read that?
Yeah, they're complete. Yes, exactly. I'm going to scroll.
test.
I'm going to scroll in just a second. So there's this long list of examples. The New York Times wants to show the extent to which OpenAI/Microsoft is stealing their material. That's how they would frame it. So, and the Times puts in a prompt. It's a very specific prompt. So what you're looking at here is a prompt. And there's a lot of controversy about this Exhibit J and to what extent you can replicate it, you can't replicate it. Okay, but we can fight about that some other day. And now we'll go down. And what you see on the left is the output from GPT-4. This is just a New York Times story. And what you see on the right is the actual test. This is a story about New York Times, about taxi medallions and the like. So the taxi cab market in New York City. What you see on the right is the actual New York Times story, okay? And the red text are duplicates and the black text are differences. Okay, is that all I hope reasonably clear? Okay, so when I do the example that Laura did, I always go once upon a, and then they say time, right? We know what word comes next, right? And your examples were great, and we all know how Harry Potter works. So what should I make of this? Is this, can you?
This is just classic memorization of training data.
So tell me a little bit more about that. So
the way, sorry, I had like a test go with Julie where I tried to explain transformers and large language models in 7 minutes, and she was like, no, don't do that. So I'm going to try to not do that. But the long story short is that large transformer-driven models are a statistical approximation of their training data. And the great breakthrough that transformers gave us is instead of an incredibly hazy and simplistic approximation of the training data, we can now get a much more sophisticated and complex approximation of our training data because we can train a model with so many more parameters. That's what it really gave us. All of a sudden, we're in this very, very high dimensional space. So the thing is that if there's a dimension that looks like a prompt that's long, then the space in that dimensionality is super thin. It's 1, right? So this is exactly that problem. And the thing that people just, I think, have a lot of trouble wrapping their heads around what large language models are doing, not because it's all that hard to understand, but it's just kind of mind-boggling that we do something that like monkeys with typewriters.
Yeah.
But right, this is what we did is we found a way to get the million monkeys. That's what we did. And so we just have a million monkeys, and one of the monkeys was at that typewriter, and so that's what you get.
Okay, so let me just say one more thing, and we'll see if anyone else will say, but I've got other questions. So what I think is almost interesting, the red is interesting, but the black is interesting too, because there are spots where it doesn't do what...
Right, this is the stochasticity.
Great, exactly. So make sure we get that.
Okay, so, and by the way, people talk about stochastic parrots dismissively. They should talk about it with wonder, right? It is amazing that we have developed something like stochastic parrots. Parrots are incredibly useful. Now, they aren't just parrots, right? They are not, there's no mind, there's no, large transformer-based models don't generate things that aren't in their training data. Delta, the stochasticity. Stochasticity is just the randomness. We sometimes call this temperature of a model when you're training a model. But part of how we achieve good results, good performance is some randomness in how we explore a space. Randomness works really well because it allows you, this is how we get anything novel. This is how we get anything surprising. And the thing is, humans are genuinely quite good at looking at 10 novel things and discarding the 9 novel things that are trash and finding the 1 novel thing that is excellent. And this is that's what the black is. This is just there's a certain amount of randomness in every model, and that's what it is.
Okay, Julie, now I want to ask you a copyright question if I can.
Sure.
So I want to start small and then I want to go bigger. So the small question is when you look at these examples, I want to know what you as a copyright person see. Do you see copies? Do you see derivative works? do you see, and I love what you said, I hate what you said, you called fair use a loophole. We think of it as this foundational principle in copyright law. Okay, so do you see copies? Do you see derivative works? Do you see fair use?
So, A, doesn't really matter whether they're copies or derivative works.
I agree with you on that.
Okay, because either one of those is a copyright infringement.
1061, 1062.
B,
No, take that down. Go ahead.
maybe it's fair
Do
use.
statutory references, questions about whether law professors do law. We do law.
We do
Go
law
ahead.
because we are like parrots also
Yes,
sometimes.
exactly.
And there's and there's some stochasticity there too, but we
No
won't
question.
get into that, right? So fair use is a place where there is stochasticity. You could, so we cite cases, right? You could say this is like antitrust litigation, which has not been mentioned yet, which was about fairness of storing the Google Books data for text searches,
Yeah.
right? There is a question about in the U.S. system about transformational uses versus kind of market replacement.
Yes.
And some very expensive lawyers will be litigating that.
Okay.
In the European system, there are some of those questions, but it's a little different doctrinally, so it skews much more toward setting up these scaled up arrangements to remunerate right holders, and there are more folks recognized as right holders. Either way, though, what you have tended to see in the large platform context is very often, the big platform stepping in with a system of its own, right? So YouTube has Content ID, and it shares a little ad revenue, and it does a little ad matching, and you have to be enough
Super clever.
So and Google has done something similar in the Google Books realm.
Yes.
And so again, I think from a 40,000 foot perspective, it's going to get solved, and that leads me to say, when I don't have my parrot hat on, I don't really care. It will get solved one way or the other. And there will be a transfer of money probably mediated through the platforms that control these large databases of text. And so it's not the thing that should be sucking all the oxygen up to the extent that it currently is, which is what frustrates me.
Okay, so let's talk about that. So I did want to go to that issue. So part of what you said is the copyright statute has these compulsory licenses, and that's part of how we deal with this. And you mentioned ASCAP BMI in particular. And when I heard that, my reaction was, well, that was a situation where we had lots of small right holders, and the difficulty was, how do they enforce their rights when they're being violated across the country? So we create this platform to solve that. Okay, is that the situation we face with regard to training data? So, I obviously, it was nice to have a chance to talk yesterday. I feel like I have entire weeks I spend in the ProQuest historical newspaper databases. That's all I do all week, right? And the New York Times is a wonder, and it goes back forever. And there's things, but that's an incredibly valuable thing. Obviously, we can talk about when copyright starts, when copyright ends. The New York Times, this is why they're filing this lawsuit. They don't want necessarily an off-the-rack system handed to them by Congress. They want the value of what they've created. And as you say, their content, this carefully crafted content, is very different than what happens when I go onto Facebook and type 5 random words, talk about stochastic parrots. So do you think, given the fact that we have rights holders with large aggregations of data, that the compulsory licensing approach will play out the same way that we've seen in other situations?
I think that a Google or a Meta, Meta doesn't have this, it's Google that has most of the stuff we're talking about, has very little incentive to want to come to the table and craft a one-off agreement with each major right holder.
I get that.
That wants, but this is what we've seen. There have been these really interesting debates unspooling over the last few years about mandated remuneration to news providers.
Yeah.
And it's the same exact issue, right? They don't want to, on the one hand, they don't want to mandate. On the other hand, they don't want to litigate it with each provider. They don't want to have to craft, 20 different
Yeah.
one-off arrangements. And then there's a really interesting universe of compromises that tend to emerge, one of which will be the one. I'm not sure
Yeah,
which.
right.
But I don't know. I don't think the Times gets a one-off arrangement. I think we absolutely want AI trained on good content, right? There's, as you say, right? There's a powerful interest in access to knowledge.
Yeah.
And if we're going to create these seemingly magical things that are not wheels, but much more sophisticated, right? That can generate text-based answers to questions. We'd rather have them trained on good content than on bad content. So here's the flip side: if you're trying to craft a more universal arrangement, it will cover all the crap too,
Yeah.
right?
Please
I
go.
just
Yeah.
don't see a way
Absolutely.
around
Jump
it.
in.
I think finding a solution in this game also interacts with the public opinion on this. So zoom back kind of when Google Print was started. So 2003, Google announces that they are going to scan books, some of them out of copyright, but many of them still copyrighted. And at the beginning, the discussion was really about are they actually allowed to do it? Should we block it from a copyright perspective? Then 12 years later, there's ultimately a court decision. And I think, by that time, public opinion had shifted because, many people had used Google Books in between and saw, the great beneficial value that, could be generated by having a system that, basically just spits out snippets, but it's a huge search engine on printed. And if you look at the decision also says, well, there's huge societal value created by these technologies. And so to some extent, I think that's a strategy which you see here as well. This is, let's not try to, figure out and settle all these issues right now when the technology is, introduced, but let's basically try it out, give it to the world, and then, opinion will change and influence. And ultimately, the question will more be about, all right, how do we split up the pie rather than, are there veto rights that basically will, jeopardize the technology altogether.
Okay, but then that goes exactly to your talk. So that's perfect. So I wanted to get to that. So here's what I mean by that. So I just heard a story of the value of country level experimentation with regard to this. We need places where we can actually see the value of technology and see the costs of technology, right? So if you guys had been in charge of Google Books where you don't have fair use, maybe you kill that off immediately, right? And this product another product I love, right? Though it could be better, right? We'd lose that. And so we don't want to harmonize fast. We should harmonize slow. Is that how I should see that?
So I think, to some extent, from a legal perspective, this is a bit of a weird perspective, but I think to some extent, that's what we've seen, all over again in these spaces. And even if you look at the AI Act, what it does when it comes to, intellectual property and privacy, it introduces transparency regimes. You have to provide a summary of the training data that you used, and if you violate this, then you can be fined. But the ultimate question, like do you engage in copyright violation or not, is not subject of. Is not really in the scope of the AI Act. And I think this is another. Even the European regulator was not really pushing. Let's try to solve this issue right now, but let's see how it develops.
Okay, I'm going to ask a couple more questions, then we're going to go to the room. So the room can get teed up. So Laura, let me come back to you. So here's what I thought I heard you say. Tell me if I got it right, and then I want to see what you make of it. So what I heard from you, I thought is we're supposed to deal with this not ex ante, but ex post. Memorization is going to happen, right? And then the question is, how do we control the outputs of that memorization? Is that a fair characterization?
Yeah, that's pretty much right.
Okay, so then my question is you've been watching the guardrail process at Gemini and other places. Do you go computer science's finest moment? Or do you go, oh my God, how can this possibly work?
I think that computer science has a product safety problem. That's...
But a solvable one.
Yeah, absolutely. The driving force of my personal work is that I think that technical innovation, has given our society and individuals so much. It has made our lives better. It has made them longer. It has made them healthier. It's made them more fun. but it's also killed a lot of people, and it's also harmed a lot of people. And we largely know how to handle this on a societal level, right? Like, first we got planes, and a lot of people died, and then eventually, like, we started to make them safer. We got cars, and a lot of people died, and eventually we started making them safer. The domain of drug safety is called pharmacovigilance, and it originated when a girl who was she was 8 or 9, and she was getting anesthesia, and she died. And medicine, part of the turning point to getting to modern medicine is, okay, we're going to study what happened. We're going to figure out why she died when other people, we can give them anesthesia and they don't die. And, we're going to learn from these mistakes and make them better. We don't really have much of a system like that yet in computer science, and we need one. So yeah, this is an entirely solvable problem. There is, we have been studying how to deal with the memorization problem and how to avoid it since it was understood to be foundational. Solvable. We just need to do it.
Okay, but do you think?
And to be clear, sorry, we need the financial incentives to do it. Because if you don't, if society doesn't require us to, it's not the simplest thing to do, and it's not free.
So the question I was going to follow up with is, do you think the people sitting at the table making these decisions have the right? Julie doesn't like the word incentives, I don't think. So can I use that word? But the right.
No, this is a good use of incentives.
The right use of incentives in these circumstances. Go ahead.
Incentives is a word. Right?
Yeah. Okay.
So.
No, and that's why I'm here.
Okay.
Right. I think that competition can be a powerful driver of that, and that's why I'm active in this space.
All right. So I want to ask you a question then, and then I want to ask a privacy question, then we'll go to the room. So and I don't know anything about this really, but I associate with the European Union something we think of as the precautionary principle. Is that fair?
Yeah.
Okay. And I don't know anything sophisticated about that at all, but I hear that as either don't or really go slow. And that's the response to the world that Laura described, which is sort of let Wilbur and Orville fly and we'll see who survives, right? How should I think about, is this a space where that idea really matters? Or do we go, no, once again, Europe's wrong, we're going to go?
So I think, if you look at the AI Act, it's definitely, motivated by a precautionary principle, perhaps not necessarily in the sense that it's slow, but in the sense let's try to get all the information and the data that's necessary in order to, make some decisions. Now, the trade-off is, of course, that, it took the European Union 3 years to, come up with the AI Act, and, there's a huge governance structure that's needed in order to do this, and whether this is the right bet, is the world, or is at least the European Union better off by doing this? I mean, that's a very, very pretty open.
Please.
So how many people flew to get to this conference? Okay. If you have a look when you fly back, the United States of America's Transportation Safety Authority is using facial recognition now. Those machines are made by, yell it out, Idemia. Idemia is a French company, right? Why are we buying our facial recognition for air flight security from a European company? Because that company produced a superior product. Why did that company produce a superior product? It may have had something to do with attention to data quality and accuracy issues that have bedeviled companies operating in the facial recognition. I don't want to call it a facial recognition industry, but I guess I just did, right? Mandates to attend to things like privacy and data quality and bias can be powerful catalysts of innovation. We see innovation in Europe in the green technology space, and a lot of that is traceable to mandates for sustainability that largely don't exist here. So it's just that the conversation here is weirdly and theologically one-sided about where the innovation is and where the incentives need to be, and that's a problem for us, I think.
Randy, could I just say one more thing?
Absolutely.
Just so I don't get absolutely murdered when I fly back to Boston. I should say, right, we do have a burgeoning community of people in computer science who who care about this, like the trust and safety community that has grown up around online platforms is an important and growing space. There are many people who are doing a lot of work on, fairness, accountability, and auditing of algorithms. It's another growing space, but it's very nascent. My own university has introduced, Northeastern University has introduced a code of ethics for engineers that they're now required to take an oath when they graduate. So I don't mean to say that we have nothing. It's just we are many decades behind other disciplines. That's all.
Okay, I want to ask one last question, and then we'll go to the room. Yeah, exactly. So I want to ask, privacy was supposed to be part of this. We haven't said much about privacy. So I guess I want to try to frame the question this way, which is we've obviously got laws in Europe. We have federal laws, but we haven't done that in a while. Obviously, states like California are moving forward. I guess there's a couple perspectives on how privacy might work, which is we should be concerned, right? So the surveillance state, surveillance capitalism vision, and now AI is going to accelerate that. I heard a little of that earlier. Another vision, another issue is, oh my God, now we could bring together a bunch of data that we could actually learn a lot from. And that would be really socially valuable. And maybe the concern there is that, the economists like me won't put my data in because I hope to free ride on everyone else. We all can't free ride it. We all can't free ride. So do the private incentives and the collective incentives line up there in an intelligent way when we're talking about what we can learn from this data? We'll just go down the row and then we'll turn to the room.
So there's definitely tension there. I think this is not easy. The main problem I see there that, if you look at this from a privacy enforcement perspective, often it's just not, we don't know exactly where the data is coming from.
Okay.
And so this is also why, privacy law, even in Europe, hasn't been very effective in, against large language models. And that's, again, something which AI tries to solve. But this is
okay. Julie.
So to the question, are there tensions there? Yes. The answer could be many hours long. There are canonical examples where there is no justification for doing anything other than handing the data over so we can learn from it.
Okay.
Public health in a pandemic probably being, the most recent and accessible one. The problem right now, especially in this country, is we're sort of ceding to the usual suspects, right? Just go to town, innovate. Social good will result, and you don't have to tell us too much about your data and where it's coming from. And it's, as Laura just illustrated, that's not how we have handled other major techno-social industrial developments with large and potentially harmful social implications. So it's strange.
Please.
I don't think we have to speculate. I think we have lots of historical evidence on this. People are very willing to share data if you tell them why. People are, the number of people who tick that box to say, yes, I will share, you can share my data for research purposes on their HIPAA agreements, quite high. My core area of computer science research is in internet measurement. Don't get me wrong, you have to clearly explain to people why you want them to donate their data, but I don't really have a huge problem getting research participants. So, in general, if you explain why and people think it's a worthy cause, many, many people are willing to donate their data. On the other hand, virtually everyone, when they get that pop-up, says, ask this app not to track. So I think it's this is like a fundamental question of informed consent.
Okay, let's turn to the room. Right there.
Hi, I'm Annette Matty from Stanford. I hope you stay here for the last session so we're not alone in the room. It would come up again. But to this, I happen to know about an area of knowledge in which there's just a lot of confusion. And even the New York Times, with the carefully curated content, is getting it wrong all the time, and we're in debates about mistakes and errors, falsehoods that they in this area. So what concerns me is there something called truth? Is there something called knowledge? So this notion that we're going to just build on what we knew before, and that by just because the fact that a lot of people wrote something before that we should perpetuate that horrifies me in this space where I am, where I'm trying to get rid of nonsense that affect policy debate. And so you'll never be able to get rid of them if they get perpetuated through this FI. In other words, is there any kind of refereeing process that can be independent, that can actually somehow get nonsense out of political discourse when there's just so much of it perpetuating, all kinds of information spaces to the point that, as even, whatever his name is, who wrote "Amusing Ourselves to Death" said, political discourse is becoming nonsense. And he said that about cable TV, not about social media or AI in 1985.
What do we want to say?
This is why you don't want necessarily to trust a foundational model trained on all of YouTube, right? But it's also, I think, important to stress that on the one hand, this is why it's important to have the conversation about the training data and where it's coming from. And on the other hand, we also have forgotten how to have intelligent public conversations about nonsense. So we bend over backwards not to offend people who spew the most ridiculous conspiracy theories, but also we play gotcha with people who make mistakes. And people who make mistakes then contort themselves into pretzels trying to deny that they made mistakes, right? And all of that is worth a very long conversation that we don't have time for here. So I think there are sort of multiple levels of attack.
Other thought, please.
So just shortly, I think this is why competition between LLMs is important. There will be hopefully LLMs with high quality content, curated content, low quality content. So,
If I could ask people to just take one thing away, large transformer-based models have no facts. They have no knowledge. What they have are sequences of tokens. And if there is a frequently repeating sequence of tokens, that's not a fact. It's just not the same thing. It is a frequently reoccurring sequence of tokens. So I just really hope, if I could really wave a magic wand, I would remove the word hallucination from our collective vocabulary, because large language models don't have minds. And the sooner we can get to talking about what these things are, I think we can have a more productive conversation.
What do you I have to jump at that. So do you like a different word for the phenomenon? The first time you encounter this, right? And you run a search and you ask it a serious question, and it says, here's the answer. And you go, okay, provide citations. And the citations come back and they're all fictitious. Is it wrong to have a label for that? And if not hallucination, then what?
I would prefer a label that doesn't imply a mind. The thing is that large language models, they're not modeling facts.
I understand.
There is a new thing that we're developing called retrieval augmented generation, where what we are trying to do is wrap what large language models are really good at is style of language usage, or style of image, or style of video. What we're trying to do now is to find a way to go figure out your fact and then wrap that nice language around it. But we're just not there yet. It's like a year off at least.
Let's go all the way to the back, and then we'll come here. Yeah, all the way to the back. Ooh, we're going to make this person run back and forth. That's my strategy.
Thank you so much for the great panel. I had a quick question more. I'm an MBA student, and in a lot of our classes, we're talking about AI from like an employment standpoint, whether it's like a complement or a substitute. In particular, I think something that scares a lot of me and my classmates is that we might be training the very models that might be replacing us. And particularly from like a property rights standpoint, just curious to get your thoughts on, how should we view that from like an employment standpoint, and particularly for people that are trying to join the workforce soon.
Thank you. Please.
So I think someone in the previous panel said this isn't just a conversation for competition lawyers or technology lawyers. The NLRB, like the employment folks, need to be in here as well. We do another thing we do really well in the U.S. is we act as though asserting property rights over things can solve the problem. This is kind of a multidimensional regulatory problem that touches, as your very good question indicates, many, many, many fields, which bears in the discussion on the previous panel about whether existing agencies can do this, whether you need a new regulator, how authority needs to be set up to just even start tackling these questions. We have a project at Georgetown Law called Redesigning the Governance Stack, which has a somewhat different take on how you would set up the new agency and what it would do and where it would fit with other agencies. Some of the stuff is on the web and you can find it. I think what I want to say is property rights won't probably get you where you want to go. We have a very rudimentary and kind of demonstratedly inadequate worker protection regime in this country already before you even bring in AI. And it is very much to the advantage of even the graduates of our most elite business schools to start questioning that, because we can't all count on being part of management when we get out.
Other things here?
I would just say that employment and worker disruption from technology is thousands of years old. And that is not to say that it isn't, a real problem for every one of us who lives through it. It is only to say that every one of us will live through it. And surviving those disruptions is more, I think, about, on a personal level, flexibility, willingness to learn, and ability to adapt. And on a national policy level, a recognition that not everyone can do that.
We were going here next. Yep, right there.
Hi, Leah Nyland from Bloomberg. On our panel about Google yesterday, we talked a little bit about those news bargaining codes. I wish that we had a little bit more time to go over them. I think I'm a little bit less optimistic than you are, Jill, just because Google and Facebook were very, very, very opposed to those codes and still are very actively opposing any other ones being proposed around the world. But just to sort of go on something you had said and Josh had said on the other panel is that, the big data companies have a lot of data. That's obviously very true. But it seems to me that really the thing that they have that like the New York Times doesn't have is they have a lot of money and they have a lot of computing power. Like the New York Times could theoretically do this themselves, but they do not have the computers. So like, what is the best way to resolve that sort of a situation?
That's just another tiny little narrow question. I'm being sarcastic. So it has got to be the case. Let me answer your question this way. So there was a discussion in the previous panel. At one point, somebody said, it's the bottleneck is the access to compute. And at one point, somebody else said, well, if you regulate uses, the business users won't be able to innovate. There are so emerging from that was a choice set that seemed to consist of mandate access to compute, but then leave the innovators free to do their thing. There are other choices in the universe, right? If you've got the provider of what, since we are where we are, I'll call an essential facility, although I recognize that's a problematic label. Right? But if you have the provider of an essential facility, then there are choices, right, about what that provider's responsibilities ought to be, and they don't stop with access, right? There are other questions that we could be asking and other kinds of about access to good quality data, right? About kind of a joint and several obligation or a joint and several obligation, I'll say, to take care not to cause harms. I wasn't here yesterday because I had to teach. I hope to God somebody talked about the energy consumption that is associated with this compute and is associated with every training run for every one of these foundational models. So it also would not be correct to say, hey, guys, let 1,000 flowers bloom, mandate access to compute as much as you can all the time for everybody who wants it, and let's all burn ourselves up. So these are questions that I think I shudder to say in the Gleacher Center at the Chicago Booth School of Business reach far beyond the traditional kind of purview of antitrust and competition law and need to be the focus of a kind of more global and heterogeneous conversation.
All right, we're going to get one more question in, ideally from someone we haven't heard. You want to say something?
I want to say something. I'll try to keep it quick. I too was really worried. 6 months or a year ago, I was really worried that, oh man, this is so expensive. This is so intensive. There's going to be like 2 or 3 foundational models, and that's all we're going to get. And it's going to be this problem where there's only a few people who can possibly do this. But that's just not what we've seen. There's been maybe not 1,000 flowers blooming, but there has been, call it a mushrooming of many new models that are great. Like the new Databricks model, the performance is excellent. Claude, very good. The mixed draws, you have choices, open source, closed source. I mean, there are really great choices coming out every few months, and it's incredible.
Let's go right there. Last question.
Thank you. So I just want to bring the conversation a little bit into the competition market structure space. And I have noted that all of you are more descriptive empirical scholars. And so I'm interested in so if I had to tease you on a normative vision for, how you would like to structure management and control over data and foundation models today or at some point in the future, what would be the kind of market or productive structure that you would like to see?
Please, someone.
Big question, very short answer. I think my main concern would be about, whether regulation leads to market concentration and how to help small firms. That seems to be a big problem.
Please. Julie, you want to say something?
I'm having trouble coming up with something else, right? I would like to see really serious emphasis on incentivizing less compute, right? To address some of the energy concerns, training better models with less data to do things well.
Laura?
We are working on that. I would say 2 things. One, I think the issue here is not a silver bullet for other issues. So, but that said, I think individuals should have ownership rights over their own data. And I think that they should be able to do everything that they can do with other types of intellectual property. And I think that we can build structures that would support that. But that would solve some problems. There's many other problems that would not be solved that we would need other solutions for.
Okay, if we could thank the panel, thank you very much.